No.
I had to print out last minute, sorry.
You should vote. Oh, I will. All right, good morning. I'm going to go ahead and open the Committee on Commerce. We have a big day today. Nice to see everyone. And we have a hearing to begin our morning, and that is on House Bill 60. And I would like to ask Representative Reed to please come forward. Is the representative here? I thought so. Good morning.
So sorry, I thought that the prime sponsor would be speaking first. I understand this is a continuance, but for some reason I thought that.
Oh, I'm sorry.
I've distributed what I had prepared as a floor amendment in the House, which has a couple things that I'd like to speak to. But first I'd like to speak to, and I know that you've already heard many of these points, but just really how truly terrible and tone deaf this bill is in the worst housing crisis that our state has ever experienced. Both parties promised in the election cycle that housing would be our top issue. Both parties promised this to the people of New Hampshire. This is not, even if you think that there's merits to this, this is not the right time to pass something that attacks tenants' rights. We are in a 0.6% vacancy. It is impossible to find housing. I'd worked on other bills where people had testified having to apply to dozens of places just to find an apartment to live in. And most of the people who struggled to find a place actually had to leave the entire state, which is a loss of workers. As a reminder, these are good tenants by definition. These are tenants who have paid their rent on time every month. These are tenants who have abided by all the stipulations of their lease. This is just creating an additional reason or a reason to kick a good tenant out in a time where it's impossible to find housing. In addition, so I'm deputy ranking of housing in the House. When we had this hearing in the House, the sponsor had said that there's concerns about increased eviction, but this isn't a problem because it's a revolving door, because you might kick someone out, but you're bringing someone else in. And that just isn't accurate, because this creates a record of eviction. If someone can't find a place within that 60 days, they have to be evicted. And that is on their record, which makes it even more impossible in a 0.6% vacancy to find another place to live. But not only are you creating a record of eviction on that tenant who paid their rent on time every month and abided by every single other stipulation, but also these landlords are not bringing in people off the streets. They aren't reducing homelessness by bringing in people off the streets. They are renting to other people that have not been displaced. So it is adding to the homelessness crisis. In addition, all of the reasons that I heard for this bill to exist in our committee are already covered by law. If you want to change the usage, that's already covered. You can kick someone out if you want to stop renting it, give it to your mother-in-law, whatever. All of those reasons are already covered. So the amendment simply says that this would only apply to 12-month leases or greater, and that it only applies when the rental vacancy rate reaches what economists think is the healthy level of 5%. So if we are in a crisis, which is under 5% vacancy, this would not be allowed. You wouldn't be able to kick good tenants out just because. And I want to wrap up by saying that the other thing that I heard that was very, very troubling during the hearing in the House was a lot of testimony around what this is really trying to do. For example, we heard this testimony from tenants, a landlord might rent to someone and then that person has a bumper sticker that has a political message opposite to what the landlord likes, or that person apparently starts dating someone of the same sex or whatever. Most of these things are protected, but this is a way to get rid of people that you just don't personally like. And in a housing crisis, we shouldn't be making people homeless just because we personally don't like their politics or the way they choose to live their life. So anyway, I think that this is a very reasonable compromise position that I hope sincerely that the committee chooses to consider. Thank you.
All right, thank you, Representative. Any questions? Seeing none, thank you. right. Unfortunately, because of the large number of people speaking, I'm going to limit testimony to 3 minutes, please. So we will do that. And I'm going to go to Representative Kathy Staub from Hills 25. Good morning, Representative.
Good morning, Senator, Mr. Chair. Good morning, Mr. Chair, members of the committee. For the record, my name is Representative Kathy Staub, and I represent Hillsborough District 25, which is Ward 5 in Manchester. It's a working class district, and half of my constituents are renters. Thank you for taking my testimony. Today, I'm speaking in opposition to House Bill 60, which would end good cause eviction protections and allow landlords to evict anyone at the end of their lease. I have provided the National Low Income Housing Coalition 2025 gap report. There are 2 sheets of paper there that give you some more granular information about exactly who will be impacted if HB 60 is passed and allows for the eviction of anyone at the end of their lease. What the report shows is that the shortage of housing in the state is not universal across all income levels. For every 100 renters at 100% of area median income, there are 105 affordable apartments. For every 100 renters at 80% of area median income, there are 101 affordable apartments. However, things get more difficult at 50% of area median income, where there are only 65 affordable apartments for every 100 renter households. And for extremely low income households, typically people who are disabled or on Social Security, there are only 39 affordable apartments for every 100 households who need them. Right now, about half of all the 157,000 renters in New Hampshire are rent burdened, meaning that they spend more than 30% of their income on rent. And what that means is if they lose that apartment, then they're not going to be able to qualify for another apartment that they can afford. So you have people who have seen their rents go up astronomically in the last few years who continue to pay their rent for example, there are 27,000 extremely low-income people, people who are disabled, people who are elderly, who are spending more than 50% of their income on their rent. In Manchester, 30% of area median income is $32,000 a year. If you're spending more than half of that on your rent, that doesn't leave a lot of money for everything else. So these are people who are skipping their meds and visiting the food banks in order to make that rent payment, because that's the only way that they can be assured of not becoming homeless. So, these are the, people who are most at risk. If we set off, what we will be doing is setting off a heinous game of musical chairs, where people are put out of their apartments and they have to go find another one. And the people who are going to be left on the curb are going to be the elderly, they're going to be the disabled, they're going to be the single income households.
We're at 3 minutes, so if you could wrap up.
All right, I will.
Great.
Thank you very much. As a state, we have a lot of work to do to create more affordable housing.
Wrap up, please.
Yep, and I appreciate the efforts that you've made, but as you know, these things take time, and I urge you to ITL this bill to avoid destabilizing this precarious position we currently find ourselves in, and thank you very much.
Thank you for your testimony,
You are
Representative.
welcome.
Appreciate it. All right, Jonathan Hill and William Pierce, you signed in together. I don't know if you want to come up together.
Sure.
All right. Good morning, gentlemen.
Good morning, Mr. Chairman and committee members. My name is Jonathan Hill. I'm a member of the New Hampshire Rental Properties Association and a landlord in New Hampshire for over 35 years, and I'm speaking in favor of HB 60. Bear with me as I go through my notes. I appreciate the understanding.
3 minutes.
Yes.
All right. Sorry about that.
I'm a landlord also.
Your microphone, please.
Okay. Get it closer.
There you go.
At least
There we are. And I'll give you guys an extra minute or so.
Okay.
Okay, thank you.
A lease is a contract with a clear defined beginning and end. And when we go into a lease, both the landlord and the tenant are agreeing mutually and voluntarily that it begins here and ends here. And at the end, it's open for renegotiation of the terms within the lease. But that should also include the end date, because a tenant should have stability and expectation of expecting housing, and they should expect the housing for the period of the lease as much as I would expect to provide the housing for the period of the lease. But after the lease is over, it's pretty much the termination of it. And so at that point, we would not kick, as the first speaker came up just a moment ago, using that as an excuse to kick good tenants out. Definitely not. The tenants are our customers. We need their income and we want those good tenants. We're not using HB 60 to kick out good tenants or because we personally don't like them. I need my units full. I need them to pay my expenses and my mortgages. So I need these customers to stay. So why do we need HB 60? Well, sometimes there are reasons that don't, especially the subjective ones. Yes, there are other emergency reasons that we can evict tenants, and they're listed for restricted properties, and we all know about those. But when some of them don't quite meet what subjectively might be supportable or justifiable in court against a judge who is not intimately familiar with, dealing with a particular person on a daily basis, it can make it difficult. And sometimes it's better, like any relationship, to part ways because they might not be getting along. This particular bill provides a 60-day notice so that you would give the tenant 60 days to be able to understand that, okay, I'm not going to renew your lease. However, if you're saying, okay, well, we have other reasons, the eviction clauses, if we go with that, now we're only giving a tenant 7 or 30 days notice before we're enacting eviction, which is actually less than half the time. So this HB 60 is requiring me to give the tenant more time, more than double, in fact, to notice that we're going to be going down a particular path of terminating our relationship of being tenant-landlord.
About a minute and a half left.
I'm sorry?
Minute and a half left.
Okay, thank you very much. And so going down the path of an eviction is very difficult for a landlord, as it is, I'm sure, for a tenant as well. But for me, it's the moment you start an eviction, the rents stop and my utility payments continue. The court costs that I have to pay up front in order to make it happen. So my costs increase. In order to use those measures, my costs increase dramatically. So I have to raise my rents overall to guard myself against this. So that's why the second speaker regarding why rents are going up is because if we're being forced to use these reasons, it costs me more money. And so I have to guard against that. It's like whenever you take like a bid on a job, for example, you have to overbid a little to build in costs for any unknown expenses. So
Can I make one point? If someone's given a 60-day notice, that doesn't mean they're going through the eviction process and they're going to have that stain on their credit record. I mean, someone could just move out after 60 days. And
yep, it also keeps the eviction off of the credit record, and that's of the court record rather.
All right. Thank you.
That's
both.
basically it.
Okay,
Thank you
Any
very much.
questions? All right. Thank you. Thank you, gentlemen. We have Elliot Berry up next. Good morning, Mr. Berry.
Good morning. Thank you, Mr. Chairman, members of the committee. My name is Elliot Berry. I'm here to testify in opposition to the bill. I believe we have some letters from 3 different landlords owning over hundreds of units in New Hampshire who are opposed to this bill, as we are. I was an attorney at New Hampshire Legal Assistance for 47 years. I believe I'm the only person in this room who was in this room when the law passed 40 years ago. The question is, why do we need to change the law that has been in effect for 40 years? Let me just walk. First of all, Senator Ricciardi asked at the last hearing, is this a new ground for eviction? Without question, it is a new ground for eviction. And the question is, why do we need a new ground? We list every common fault that you can evict for. On top of that, The law specifically says that other good cause, which is a ground for eviction, includes but is not limited to any legitimate business or economic reason, including rent increases, rehabilitation of the property, moving in a family member. In addition, when this law was passed, they added a hearsay exception. So at eviction hearings, landlords not only could use as competent evidence, they could introduce the records of the landlords about tenant complaints so that the tenant doesn't have to testify. The Realtors Association has acknowledged that the eviction rate in New Hampshire today is higher than in the other New England states which do not have good cause eviction, which underscores my point that there is no reason to do this. Any legitimate reason a landlord has to evict somebody, they can evict somebody. People that won't move at the end of their 60-day notice often for the same reason they don't move at the end of their 30-day notice today. And that reason is they don't have anywhere to go. The bill will in fact enable unlawful discrimination and retaliation for making good faith complaints. Why? Because the law now would provide an independent, non-discriminatory reason for the eviction. And in the unlikely chance that the judge does not immediately reject the claim because there's an independent, non-discriminatory reason, then the tenants, who are overwhelmingly representing themselves, will have to take the burden of proof to show that the landlord's eviction is pretext for the other reason. The bottom line is the vast majority of tenants couldn't possibly do that in regard to retaliation or discrimination.
We're at 3 minutes, sir, so if you could wrap up, please.
If I could, just let me talk about
Very briefly, please.
3 problems with the.
I don't think we have time for 3 problems.
Number one, when the sponsor testified in favor of the bill, he gave you a scenario of 1 year.
Sir, your time is up. I'm sorry. Thank you. All right. Next up, Brian Shaughnessy, please. Yes, ma'am. You may ask a question.
Thank you for taking my question. So if there's a 1-year lease and somebody stays beyond that 1 year with agreement for the landlord, does that mean that they're liable for eviction at any time after that?
Absolutely. And as the bill is written, it is not unlikely, although not entirely clear, that even if I stayed the apartment for 10 years after the expiration of that lease, I could still be evicted for the expiration of that initial lease. And that's because of the or tenancy language that's in lines 3, 4, and 5 of the bill.
One
Follow up?
Thank you. So you alluded to this, and I thought upon first reading this bill, this is only going to enhance the work of the Human Rights Commission, because our fear is that people are going to be evicted for illegitimate reasons because the law already allows them to evict for a legitimate reason. So how does that impact a tenant's right to go and seek help because of an
Sure. The tenant could definitely go to the Human Rights Commission if the discrimination is covered, or they could go to the Housing and Urban Development. The problem is those processes take between 6 months and, for the state, probably 2 years, long after the tenant has been rendered homeless.
Thank you.
Any other questions? All right. Thank you, sir. Brian Shaughnessy, please. Is Brian here? Not seeing Brian. Kate, I'm having trouble with your last name, Mary.
Marquis.
Oh, Marquis. Okay, got it now.
French last
Now I see it. All right. Good morning, Miss Marquis.
Good morning. Greetings, Senate Commerce members and Chairman Innes. My name is Kate Marquis, and I live in Manchester. I own a small business in the city and serve on our local housing commission and land use code update steering committee. I also happen to be a renter for nearly 25 years, and that's how I'm speaking to you today. To more than about 15 years in Ward 1, Senator Murphy. I've almost always been fortunate enough to find a place I want to live and have the owner be a real live person. I've lived in my current apartment for 6 years, and I don't find it at all painful to send my rent check to my landlord, Chris. He's a reasonable human being, and so am I. My door's always been open to my landlord when he needs to get into my apartment for whatever reason. That's part of the ease of our relationship. Since HB 60 last year, I now hesitate. Feeling any interaction I have with him may now be a reason for him to decide not to renew my lease. One distinct interaction sticks in my head. He was walking through my apartment to get to the other side of the building. I had a few spiritual trinkets on a shelf. He asked me what they were. I replied they were a mishmash of different religious objects that ground me spiritually. Without thinking, I said, many roads, same destination. He paused and said, no, that's not what I think. He's a Christian man, and this was my reminder. This happened before HB 60 passed the House earlier this year. I now question whether that interaction will cost me my wonderful apartment. This law makes it so easy to evict tenants that evicting based on a whim or a feeling becomes feasible, which is terribly unsettling as a renter. What if I don't park straight enough or wasn't quick enough to bring the trash barrels in? Is this now grounds for not renewing a lease? HB 60 creates an unsettling power balance in the landlord-tenant relationship. This bill also inadvertently creates another eviction status for renters who have done nothing wrong. When I interview for an apartment, the potential landlord always asks why I'm looking for a new apartment. What will I share as my reason for looking? Sharing that my landlord didn't want to renew my lease would undoubtedly be a red flag to a potential landlord thinking there was a reason. There are other ways to get tenants you don't like out, through renovation eviction, for example, very popular in Manchester. Yes, there's a bit more to the process, and that's good. It shouldn't be so easy that it's done on a whim. This bill, during this intense housing crisis, unlike anything I've experienced in the past 25 years, is really putting the about 175,000 renting households in New Hampshire on edge. There are very few apartments for rent and even fewer that are affordable. Having only 60 days notice in this market is not enough. Have any of you had to try to find an apartment post-COVID?
You're at 3
It's a
minutes, so if
complete,
you could wrap.
I've got one little paragraph left, and I was here last week
Do it up.
for the whole session. It's a completely different experience, and if you haven't had to find an apartment, my guess is that it's hard to understand the urgency of the situation. This is the wrong time for this bill. I understand that it was submitted to fix a supposed loophole in the law. However, from this renter's perspective, this bill creates more problems than it solves for our state. Please, for the sake of all good renters out there, the ones who pay their rent on time, plow their own driveway, shovel their own driveway, and make great neighbors who do all the right things, please do not add to our stress. We can only take so much. Thank you.
Any questions? Seeing none, appreciate your testimony. Todd Marsh, please. I'm going to ask again for everyone, please stick to 3 minutes. I want to get to everyone today. All right, Mr. Marsh,
All right,
good morning.
Good morning. First, Chair Ennis, I want to thank you, by the way, for extending this second hearing. I recognize it was something you did not need to do, but you did it anyway. Not lost on me. Thank you. Hopefully my time starts now.
So thank you.
So yes, my name is Todd Marsh. I am the president of the New Hampshire Local Welfare Administrators Association. Municipal welfare managers working in city and town halls throughout our state, working with people in need, working with our landlord friends, and working for local property taxpayers. Senators, we believe the sponsors of this change are correct regarding an uneven contract weighted towards landlords. For decades, tenants have had the option to not renew leases, and landlords have not had this option without good cause. On its surface, a contract with this uneven language sounds inherently wrong. Then why has current language existed for so long? Because the ability to end a very basic need for all of us, housing, is a power imbalance, heavily weighted in favor of landlords, which is why the current law focuses on verifiable reasons to evict. And as was stated many times, there are many. The current law's language is a counterbalance to a power imbalance. Imagine a mother of 2 children a mother who struggles to pay first month's rent and security deposit to move into her new home 11 months ago, a mother employed locally and whose children attend the local schools. Imagine her lease not being renewed, not because of owed rent, not because of damages to her apartment or planned renovations, but because she inquired to have her sink fixed. Because she expressed concern of sparking electrical outlets, or she practiced her rights of turning down unwanted advances by her landlord. Yes, retaliatory laws exist. However, a tenant's need to demonstrate burden of proof will too often be challenged by the patient subtlety of retribution. These consequences are not the sponsor's intent, nor will it be practiced by most landlords. We are convinced that this will be the outcome for too many Granite Staters. This change has been presented to you as pro-housing by increasing landlord decision-making flexibility. Although flexible entry may increase, we believe the consequence of flexible displacement far outweighs the benefits of flexible entry, and it will be at the cost of our taxpayers that pay for both state and municipal services. Senators, this is a rare opportunity for you to be both humanitarian and New Hampshire frugal, and you can do so by simply staying the course. Finally, when asked by your Senate peers and your constituents, why did you oppose this change? You can honestly tell them because it caused the least amount of harm for the least amount of taxpayer dollars. In fact, it saved taxpayer dollars. Municipal welfare.
We're at 3 minutes, so if you could wrap.
Absolutely. Who is responsible for relieving and maintaining the housing insecure and unhoused, advises you to oppose this well-intended but full of unintended consequences change to the existing law. Thank you for your time.
Questions? All right, thank you for your testimony. Appreciate it. Jennifer Chisholm. Good morning.
Good morning. Chairman Innes and members of the committee. My name is Jennifer Chisholm, and I'm the Executive Director of the New Hampshire Coalition to End Homelessness. And I thank you for taking my testimony in opposition to HB 60 this morning. As we all recognize, homelessness is at a critical issue or a critical juncture across the Granite State. From 2019 to 2024, the number of individuals staying in emergency shelters increased by 44%, including an 18% increase in families using family shelter beds. And the number of people in New Hampshire staying outside or in their cars has almost quadrupled since 2019. The driving force for this issue is economic. Rents have skyrocketed while wages have remained relatively stagnant. According to New Hampshire Housing's 2024 Rental Cost Survey report, median income households in New Hampshire can afford the gross rent of only 13% of the 2-bedroom rental units on the market in New Hampshire. This means that average New Hampshire families are struggling to make ends meet and are often seriously cost burdened, paying more than 50% of their income to rent. There's an example of this in my written testimony, the story of Adrienne, a New Hampshire mom who has a solid rental history, a solid career, and a solid education, and still struggled to try and find an apartment, and is currently renting and paying more than half of her income to rent. So I'd like to note too that evictions do have significant impact on the families like Adrienne's, and their risk of becoming homeless. In fact, a 2024 study published in the Quarterly Journal of Economics found that evictions cause increases in homelessness, increase emergency shelter stays, and decrease families' income and credit scores, making it more difficult to achieve housing stability. This study found that the effects related to homelessness persisted for at least 2 years after the eviction, and the negative effects on families' financial health lasted for over 6 years. Make no mistake, no-cause evictions are true evictions with real consequences. Bearing the weight of these negative impacts makes it even more difficult for New Hampshire families to regain housing stability after an eviction, and they require more resources from the state, from municipalities, and from nonprofit services. So why is New Hampshire considering imposing these serious and long-term economic consequences on families who are not eligible for eviction under current New Hampshire law? And why now, when these same families are struggling against a rental economy where there's nowhere near enough units, never mind affordable units, in New Hampshire's supply to meet demand, and families' earnings have not risen in tandem with the cost of housing? Homelessness is already at a critical point in the Granite State, and right now prevention is worth at least 10 pounds of cure. So I urge you to vote for the health, stability, and safety of families by voting no for HB 60. And so thank you for your consideration.
Thank you. Any questions? Appreciate your testimony.
Thank you.
All right, next up we have Violet. Violet, I'm having trouble reading your last name.
Lucky.
Okay. Good morning.
Good morning. Dear Chairman and members of the Senate Commerce Committee, my name is Violet Lemke. I'm a student of psychology at Plymouth State University and a lifelong resident of New Hampshire. On behalf of myself, I present this testimony in opposition to HB 60 in regard to the termination of tenancy at the expiration of the lease term. I believe that stability is the foundation of well-being. Without stability, it's a constant uphill battle for us to find ways to fill our essential needs of belonging and safety. 3 years ago, I completely gave up the little stability I had to move to another town and try and set some roots there. I arrived in Plymouth alone, hoping to find a home and a better, kinder life. With the support of the university, I've been able to find that home and life. However, as an independent woman, I constantly worry about where I will live in the future. I'm incredibly lucky to currently be surrounded by a community of supportive people. One of the greatest forms of support I have received from the university is stability in housing. Because of this, I've been able to overcome massive health challenges without worrying that the home I'm currently in will be taken away arbitrarily. As someone who has finally found a home in New Hampshire, my greatest fear every day is that it will be taken from me. In the coming years, when I have to leave student housing, I know that it's going to be a great challenge to find another home in Plymouth. As a disabled and queer individual trying to solely support myself, I fear that removing restrictions to provide just cause for evictions will be used to discriminate against me and other people like me. For people like me whose community is everything, to them eviction can cost everything. For the sake of young New Hampshireites who are doing their best to find a sense of stability and community, I respectfully urge the committee to vote against HB 60. Thank you for your time.
Thank you for your testimony. Any questions? If you see President Burks, please tell him I send my regards.
I will, thank
All right.
you.
Thank you. All right. I cannot read the next name to save my life. I think the first name starts with an M and maybe the last name with an H.
Yes, Mason.
All right, come forward and please tell us who you are.
I'm Mr. Mark
Oh,
Hilton,
have a seat.
Senior.
All right, if you could restate it for the H.
It's nice to meet Mr. Mark Hilton, Senior. It's nice to meet your panel, committee,
Good morning.
chairman. I'm here on the low end. My family founded the estate in 1623, the Hiltons. My aunt, great aunt Mary Benny Wentworth, the first swing justice was her uncle. I'm here to speak on our tradition. We are a community of people that comes together, housing, jobs, and all that. When you start taking the fabric away from that, and when the landlords run their muck on their tenants, what happens? It breaks down. Fabric breaks down. They become homeless, draws more research on the law enforcement, hospitals, state funding, municipality funding, where you don't have. And the country, state of New Hampshire, ain't look forward for this. A lot of states are looking at you and saying, what's going on up there with their housing and other problems? You got a crisis of homeless. You got a crisis of drugs. You got a crisis now, you want to evict people out because the landlord wants to get their pockets a little deeper. They want to push their weight around because they don't like somebody. You know it takes 500 applicants a day for Manchester to get an apartment. You know how much it costs? $65 to $85 to get that application in their pocket. And they pick the best of the best. And you gotta have 5 years of credit. Is that right to the old days? Was the founding fathers want this? They'd be rolling in their graves. And I know that for a sure thing. Because this country and this state is built on Christian faith, love, decency. And this is an independent state from an independent colony from the Hiltons. And let me tell you, I'm speaking on the family tradition and the hospitality side of it too. You ruined the good name of the Hiltons, the good name of the state of New Hampshire, but it comes from England. You ruin the names of the towns if you move forward with this bill and give these landlords the golden path to get richer and pick who they want and annihilate the people who doesn't deserve to be annihilated. We all equal. That's our Constitution. We'll stand on it and fight this bill and tell the landlords to take a hike. Thank you all.
Thank you. All right. Appreciate your testimony. Lily Wellington, please.
Good morning, Chair Ennis and members of Commerce. Thank you for the opportunity to speak this morning. My name is Lily Wellington, and I am the Executive Director for the State's Commission on Aging. So I wanted to use my time this morning to speak to you about specifically the aging demographic in New Hampshire. This is probably not a surprise, but 27% of our state is aged 60 or above. So by 2030, that number is expected to creep up to 30% or above. And this matters in particular to HB 60 because renting allows a really flexible opportunity for an aging population. So imagine, if you will, a grandparent or a neighbor who no longer wants to plow their driveway or would like to have a first floor unit with an accessible bathroom. Renting allows that flexibility. Currently, right now, we're all here because housing matters, and we know that there is not enough flexible housing opportunities in New Hampshire, specifically affordable units. And so one of the things that I think is concerning in particular to HB 60 for the commission is that this could potentially pull a thread in terms of housing options for an aging population and for those other vulnerable or at-risk demographics. And this essentially just pushes costs back onto communities and towns. So if you are finding yourself with an eviction notice for no reason, right? This would essentially, you are forced back to go to your town and to say, I don't have first and last month's rent. I don't have access to a financial means to hire a mover. And so this could essentially push back into higher and higher, more expensive and more expensive levels of care for individuals that don't need that level of care, but they do need that level of financial support. So I think in terms of thinking about how we can meet flexible housing demands, the commission would advise against HB 60. Thank you.
All right. Thank you. Any questions? All right. Appreciate it. Jessica Margison. Good morning. And we're ready. If you can turn your microphone on, please. Thank you.
Is that better?
That's all.
There we go. All right. My name is Jessica Margison. I run a tenant. I'm here representing myself. I run a tenant clinic out of Manchester for a little over 4 years, helping tenants get ready for eviction court, learn their rights, or find resources they need to help them stay housed or get rehoused. Many New Hampshire renters do not have the luxury or the time to be here as I am today to testify. I am grateful to be able to be here and speak out in opposition to HB 60. So many renters I have spoken to would if they could. Tenants have become disenfranchised and feel like their complaints fall on deaf ears, is something that I commonly hear. Per the 2023 census, in New Hampshire, approximately 157,000 renter households were recorded in 2023. Representing 31.9% of all households. This figure indicates that about 1/3 of households in the state are renters, and that is those who have replied to their census. We know the issue with getting as many people to apply as possible. And while the line may be blurred on whether housing is a basic human right or a basic human need, I feel Like we can agree that creating a hostile renting environment is not a way to encourage New Hampshire renters to stay in our state or train skilled workers to move here. Tenants have no bargaining power in this housing market, and this bill would take what little we have left away. Over the last few years, we have watched program terms expire at multiple apartment complexes for affordability programs that were not renewed. We expect to see more. A current example is the Fairways in Derry. A tenant from there that I am currently helping is a single hardworking parent of 3 children, 1 disabled. With her combined income, she currently only qualifies for a 1-bedroom. We met with Southern New Hampshire Services to help them apply for emergency service grant. They would be an ideal candidate, we were told, but currently they are awaiting funding. There is no money to help her at the moment. They have till the end of June of this year to leave, or their rent goes up substantially to where they cannot afford. We currently have insufficient financial rental assistance to help keep people housed or rehoused. This only further complicates things. With the possibility of having to move every 6 months, those expenses could easily reach $8,000 a year just in security deposits and first month's rent, not to talk about the application fees one encounters. An expense most cannot afford, nor do we have the resources to even help those in need. I currently counsel tenants about how they can live with less, not what I ever pictured. I prefer to help them reach for more. I now help tenants weigh which rights are worth standing up for, which layouts work best when living in smaller apartments than what they need just to keep a roof over their head. This bill is argued as a contract right issue, but I say it creates a tenant rights issue. When tenants are scared to speak up about repairs needed or stand up for their rights, it creates an oppressive atmosphere. Do you see where this is going? Pay more, have less.
We're at 3 minutes, so if you could wrap.
The last thing I want to speak on is something that was mentioned a minute ago, and I picked this as my last thing to say. I have a tenant who 2 years ago complained to the Human Rights Commission because her landlord told her the apartment was not created for disabled people, she should just move. In that time, she was evicted, was homeless, got rehoused, and is still yet to hear from that commission. Thank you.
Thank you. Are there any questions? All right, appreciate it. Vanessa Blaze. Morning, Ms. Blaze.
Good morning, Senator. Good morning, members of the committee. My name is Vanessa Blaze, and I serve as the Director of Policy and Planning for the New Hampshire Council on Developmental Disabilities. When I was here last week, I unfortunately didn't have an opportunity to speak, but I did deliver a letter from the council, and I'm hoping that each of you had the opportunity to read that letter. I'm going to be as quick as possible. I just want to highlight a couple of things. The first being that when the Supreme Court made this decision over 40 years ago, it was stipulated in that decision that one of the reasons why they wanted to protect people from the termination of tenancy is because of protecting people with disabilities from being unstable in their housing. And we believe that eliminating this protection is, in a way, eliminating their rights under the Fair Housing Act. Because if you can evict someone for no reason, then you don't have to prove whether or not you're evicting them for discriminatory practices. And the tenant has no way of proving that. Also, I just want to speak to the discussion about how a contract is a contract is a contract, which is something that I've been hearing year over year when we have been opposing this bill. The Supreme Court decided that this contract was a different kind of contract. And we all know that there are many different kinds of contracts that exist in our society. I was an educator, and when a couple of times our contracts expired before we had a new contract, and we didn't pack up all of our things and leave the school. Why not? Well, because as a society, we determined that that would be ridiculous. To be plain. So, you know, a society, we decide that different contracts mean different things. And when you sign a lease, I'm a renter. When I signed my lease, the understanding between myself and my landlord is that that contract stipulated what my rent would be and what the stipulations of my tenancy would be. It was not decided that when that lease expired, I was expected to leave. So I just kind of wanted to make a statement around that. Also, I want to bring to the attention of the committee that displacement it shatters the fundamental security that families have, especially for people with disabilities. There is a committee that is going to be reconvening this summer, and that committee is around helping people with developmental disabilities gain independence by having more stable housing. This bill would directly oppose all of the work that all of the stakeholders and legislators are doing right now to work towards finding better housing situations for people with developmental disabilities. I hope that you take that into consideration when considering this bill. Thank you.
3 minutes on the button. It's impressive. Any questions? All right, thank you.
Thank you.
All right, next up, we have Anne Marie O'Rourke. Is Anne Marie here? Pardon me? The button on, there you are, that's good.
Okay.
Yeah.
Good morning.
Good
My
morning.
name is Anne Marie O'Rourke, and I oppose HB 60. I am 77 years old, divorced RN that lives alone. I live on a limited income, Social Security, plus a small monthly annuity. I lived in my previous apartment in a house which was family owned, not my family. I had always had 5 apartments. I had always paid my rent on time and was a good tenant. I cannot resume my career as an RN due to medical issues. I lived in my previous apartment for 18 and a half years. It was my home. It sold in 23, and I could see the writing on the wall. I started looking for a new apartment. 2024, the landlord doubled the rent. I knew living on Social Security and the annuity, I could not afford to stay. I started looking for a new apartment in August of 23 due to house being sold, hoping to stay in the same area. I scrambled to pay rent, which meant going to town welfare and other groups to help me. I was mortified, never finding myself in this situation before. I received an eviction notice in February of 24 for other just cause, renos. New owner was converting to Airbnb. I kept looking for what I could afford. I signed up for senior housing in 3 places. Waiting list is at least 2 to 3 years. I felt totally isolated, embarrassed to share with friends. What could I do financially on limited income? Psychologically, I felt lost with no self-worth. I had no, I felt I had lost my self-respect. The welfare office wanted me to sign up for a shelter. I was preparing to live in my car. I had no dignity left. Lowest point in my life, would cry myself to sleep at night, unable to physically. I've had cardiac issues due to stress, this whole situation. I did find an apartment in July of 24. That's a year after I was told to leave. That could barely afford, but still struggling. It's been almost 10 months and I am still feeling the effects. To evict someone for no reason does not give people any recourse. I oppose Bill HB 60.
Okay. Thank you for your testimony. Are there any questions? All right, thank you very much. Sam Hawkins.
Good morning, Chairman, members of the committee. For the record, my name is Sam Hawkins. I represent NAMI, New Hampshire, the National Alliance on Mental Illness, and I'm here today to speak in opposition of House Bill 60. I'll be handing out my written testimony, so I'll be exceptionally brief. I really just want to focus in that we know already under current law, it is incredibly challenging for individuals living with a serious mental illness to get and maintain stable housing. This is for a wide variety of reasons, but one key contributor, of course, is discrimination in the rental process. As you've heard others testify, we do have serious concerns that House Bill 60 would make it easier for landlords to discriminate against people in the rental process. In this case, especially against people who they find out during the tenancy period has a mental illness. We have pretty grave fears that the passage of House Bill 60 would contribute to the increase of unhoused, hospitalized, or incarcerated individuals living with a mental illness. Finding House Bill 60 inexpedient to legislate will not change the landlord protections in law. Finding House Bill 60 inexpedient to legislate would, however, continue the protections in law for renters, which includes our granite staters living with a mental illness and other disabilities. I just want to finally say that this issue does feel especially urgent right now, given the housing crisis New Hampshire is facing, as others have mentioned, but also especially with the tight budget we are facing and its potential impact on housing programs. We are obviously greatly appreciative of the Senate Finance Committee's actions last Friday to restore the community mental health program support funding, but we do know the budget is going to be going to a committee of conference, and it's unclear what will come out of that. In regard to housing programs, especially for transitional and supported housing for individuals living with a mental illness. So this really just doesn't feel like the right time for this policy, if there ever is a right time for this policy. As such, we urge the committee to please vote House Bill 60 inexpedient to legislate.
Thank you, sir. Any questions?
Thank you very much.
Thank you. All right. Martin Hergen. Martin. Did I get the name right?
No.
Well,
It was close. My name is Marta Hergen.
Marta.
There you go.
Yes.
All right.
Now it matches better.
Good morning, members of the committee. Thank you for your time. I'm a housing attorney at New Hampshire Legal Assistance. I've been a litigator in New Hampshire for about a dozen years, first at the public defender and now at Legal Aid. I would say over the past few years, outside of a few of my colleagues at New Hampshire Legal Assistance, I'm probably one of the only attorneys in the state who really does solely eviction defense work. Through our eviction clinics, I've probably been a part of hundreds of eviction hearings over the past few years and seen thousands of them in our circuit court. I'm just contrasting that to Representative Lynn, who is an esteemed jurist, and Lord knows I'll never be on the Supreme Court. But I just want to talk to you about the practical effects of what goes on in eviction hearings. Here's the good news: if you're a landlord, it's really easy to evict a tenant in New Hampshire already. Here's the better news: if this law passes, it'll be even easier. And I say that as someone who does eviction defense. Most of what I do is negotiate move-out agreements for tenants, because it's already pretty easy for landlords to win eviction hearings. So I'm practical. Practically speaking, I want to offer a few solutions to what may be some bigger problems if this bill does pass. You could extend this to apply to only 12-month lease terms. Because 6-month lease terms aren't really a thing, so that'll only cause confusion. If you want this to be easier for landlords and tenants and courts to understand, you could make this apply to only 12-month lease terms. You could make it so that this has to be done by a landlord within 6 months after the expiration of the lease, so that the hypotheticals and some of the tenants we've heard about being in their home for 10 years and all of a sudden getting eviction notice out of the blue, that won't be a problem. There will be some sort of deadlines if landlords do want to move forward, and in the lease they have to do it within 6 months after the expiration of the term. And the third thing you could do is you could delay implementation of this bill. You've heard a lot about the housing crisis. That is very real. The eviction laws that we have right now work. There are court forms. They're free for everyone to use. The judges are familiar with them. Tenants and landlords are familiar with them. This would give you, a few years, presumably, for hopefully the housing crisis to improve, and to also allow landlords, their attorneys, tenants, their attorneys to become more familiar with the working aspects of this bill and see how it would play out. So I know you've heard a lot of the problems. Obviously, we oppose this bill, but as someone who sees the eviction hearings week in, week out in the circuit court, and we just wanted to offer some possible solutions that may make this less painful. There are the obvious reasons we oppose it that you've heard today. Number one being there will be really no further burden of proof that landlords need to meet. As someone who does eviction defense, that makes me sad, because now it will make our work even harder to come up with any sort of factual defense to an eviction action against our clients. So I thank the committee for their time. If there are any questions, I'm happy to entertain them.
Okay, are there any questions? All right, thank you. think our final speaker is Nick Norman. Good morning, sir.
Thank you very much for the opportunity to speak. My name is Nick Norman. I work with landlords across the state of New Hampshire in our legislative initiative with a membership of about 3,500. There's a few points to make. I'll try to be brief. There's a lot to say, of course. So there's the argument that's been mentioned several times about increasing homelessness. I can't see that's true because if you have somebody move out and another person moves in, what's the net effect? The net effect is neutral. There's also been some talk that about landlords raising rents because of this. That doesn't make any sense. Landlords already can raise the rents at whatever level they want. That would increase the number of evictions. So a landlord does not want to evict a tenant. An eviction is the absolute last resort that a landlord would take. We want to have good tenants. We would never want to evict someone for some kind of random reason. If you got a good tenant paying rent, you'd want them to stay forever and ever. Nothing in this bill would change the volumes of rules and regulations about codes, retaliation, discrimination. None of that changes from this bill. There is some talk about retaliation. So the law is very clear on this. In the written testimony that I gave you, on the next to last page, I've outlined the entire RSA that talks about this. The RSA says that there shall be a rebuttable presumption if certain things happen, like, for instance, the tenant complains about a code violation, and there's a list of things already delineated in the RSA. If any of those things were used by a tenant validly, then the law says that there's a rebuttable presumption that that was done in retaliation. Not change that in the slightest way. It would still be the landlord's responsibility to prove their case, not the tenants. So that whoever said that, that's incorrect. And there is something that hasn't been talked about enough, which is that there is, with our market as strong as it is, and by the way, it's decreasing. We're seeing the strength of the market
About
going
15
down.
seconds left, sir.
Thank you. It would provide an opportunity for landlords to be more lenient in accepting someone that has a marginal application, because they would know that if things go south, that there would be an opportunity to have the person leave.
Okay.
And no eviction would happen if the tenant left within their 60 days. I'd be very happy to take any questions.
Any questions? All right, thank you for your testimony. The last speaker is Nick Taylor. Yeah, I thought it was.
Thank you, Mr. Chairman and members of the committee. I will be brief, but I'm Nick Taylor, Director of Housing Action, New Hampshire. We're here in opposition to House Bill 60. We've spent a lot of time this session with this committee working on housing issues, which we are deeply appreciative. Chairman Innes, you've been a leader on the Affordable Housing Fund and CDFA. Senator Murphy leading on regulatory and zoning reform, because we know this is not a healthy and free housing market that we are in New Hampshire right now. And for that, we are deeply appreciative. Keeping people in their homes in this market where they have nowhere else to go is part of addressing this housing crisis and making sure that this is a place where everyone has a roof over their head in New Hampshire right now. As I mentioned in prior bills before this, our members include developers, landlords, property managers, and more. We are frequently surveying them on their top issues that they are seeing at the State House and at the state level. This is not an issue that comes up. This is not something that any of our members have asked for. They're asking for the regulatory relief. They're asking for the financial incentives. This is not one of them. The final point I would like to bring up is we've had a lot of conversations around, if we're getting more folks into the being housing providers or landlords, if they're building an ADU, what happens if they try to rent to somebody and they realize this is not for them and they do not want to be a professional landlord? Well, those folks are already exempt from these end of lease laws. It doesn't apply to less than 4 units of owner occupied housing. So those type of folks are already have significant flexibility. So we appreciate all your work this session and ask that you oppose this bill.
All right, thank you for your testimony. Any questions? All right, seeing none, thank you, sir, appreciate it. We're going to close the hearing on House Bill 60 and go into 3-minute recess. All right, I pull the Committee on Commerce out of recess, and I would entertain a motion to go into executive session,
So
please.
moved.
We have a motion and a second. All in favor, say aye. Aye. Any opposed? All right, very good. I think we'll start with the FNs first. We have 633, 639, and 649, all of which are exciting. Through 633, I'm wondering where Senator McGue is. But 633, an act creating a legislative study committee to investigate the implementation of housing investment trusts in New Hampshire. And get to that. Do we have a motion on 633?
I make a motion to support the study committee.
All right. Then what does that mean, Senator? Is that an ought to pass motion?
For study committee.
Okay. Second. All right, we have a motion and a second. We also have an amendment I'm trying to get to, which is 633. And Aaron, do we have the representative here or no?
He's
I do
traveling.
see Representative Daniels. Yes.
Yes, Representative Daniels. Where is he? There he is. Would you like to come forward briefly? Good morning, sir. I
morning, Mr.
trust you've
Chairman.
seen the amendment. Right. To your bill.
Have I seen it?
Yes.
Yes,
Yes. And you're supportive of the amendment.
I am supportive of the amendment.
Can you speak to that a little bit, please?
The amendment is simply the original language that we put in, which establishes a definition of a housing investment trust.
Okay.
And that would allow us to continue the legal work that must be done, as well as to go after the designation of the 501c3, which the housing investment trust would be. In addition to the House language, which establishes a study committee, which is needed as well.
Yes. Okay, so we're retaining the study committee, but going back to the original language, creating the housing investment trust.
Correct. So both together would be great.
I just wanted the committee to hear that. So, all right, thank you, Representative.
Thank you.
Mr. Chair, can I ask? a
Yes,
question?
please.
Hi, Representative. Nice to see you. Thank you for taking my question. We seem to be fast tracking so many things. The study committee sounds like the way to go, and that's what the House had also agreed to. What is the harm in not just doing the study committee rather than just rushing through and fast tracking this?
The initiative you have before you is a multi-year thing. We're not going to be able to finish it all in 1 year. There are things that need to be done. There are things that need to be studied, but there are also things that we can pursue along the legal line to make sure that everything is in place, as well as said, going after the 501c3 designation. That takes time. So if you have the definition in there, then what needs to happen on the legal side is legal needs to have a customer. So that would establish a customer that legal could then come back and give their input on. But it allows the initiative to move forward in both ways. Otherwise, we're going to end up delaying it for about a year.
Thank you.
Any other questions, Senator McGue, please?
Thank you, Mr. Chairman. Thanks to the sponsors, the bipartisan sponsors who put this together, and the members of the public that have come together with yet another creative solution. If there's ever a topic we shouldn't delay, this is it, especially since it will take some time, and we have retained the ability to study this along with moving the process forward. So that's my input. I'm in full support of the bill, the concept, and the amendment, and I urge the committee to join me in supporting it.
Okay. Thank you, Mr. McHugh. Any other comments or
No
thoughts?
questions, Ryan.
Yep. All right. Thank you, Representative.
Thank
Appreciate it.
you.
All right. Further discussion? Senator.
Thank you, Mr. Chair. I thought this was an interesting idea, but not fully baked. It relied on state agencies to some part that we didn't hear from, that somehow New Hampshire Housing Finance would play a role in this, that they would become a 501c3. So I agree with Senator Ricciardi that a study committee seems to be not putting the cart before the horse, but actually progressing in a manner. I think I commented at the time of the public hearing that I don't believe creating a housing investment trust needs to involve government at think it's something that can be, happen independently. And I want to make it clear, if we do a study committee, we're not embracing the idea of this being a thing that is going to happen, that in fact it is exploring whether government needs to be involved in this at all. So I don't want to go forward with a study committee as creating this because I haven't embraced the idea of it initially.
Understood. All right, thank you. Other comments? All right, well, we do have the amendment 2024S, and I'm going to move that. Do we have a second?
Second.
Second from Senator McGue. Any discussion on the amendment? All right, we'll take the vote on the amendment. I think I know where we're going. But all in favor of amendment 2024S, please say aye.
Aye.
Any opposed?
No.
All right, it's 3-3. The amendment does not move forward. We have the bill itself, House Bill 633 with a motion. Do we have a motion, Senator McGee?
I'll be happy to move on to pass.
We do have a motion. Yes, I thought so. All right, we have a motion about to pass. All in favor of the motion about to pass on the unamended 633, please say aye.
Aye.
Aye. Any opposed? All right, that one moves along. We have a motion on consent. Do we have a second?
Second.
All in favor of consent, please say aye.
Aye.
Any opposed? All right.
Would you like me to take it out?
You want this one, Senator? I'll take it. All right, Senator Fenton gets this one. I was going to do it, but we'll let him have it. All right, 639. So it'll be fun. 639 has to do with blockchain and digital currencies. We heard a lot of testimony on this one. We do have an amendment from Senator McGue, and Senator, I'll recognize you to discuss your amendment.
Thank you, Mr. Chairman. I'll move on to pass on the bill first.
Second.
And the amendment clarifies the definition of digital asset exchange. The amendment requested by the Secretary of State and the prime sponsor. I think you should have it. It's 1909S. So I'll move on to pass on the amendment.
All right. And we have a second from Senator Murphy. All right, discussion on the amendment?
Mr. Chair?
Yes.
Thank you. I think the bill still needs a tremendous amount of work. They passed a similar bill in Arkansas, and then Governor Huckabee had to go back and change everything. I've heard from a lot of people, and I think a re-refer would make more sense so that we could actually work on this. There's a lot of concern under an ordinance 359V3 about a noise problem with this industry that could be negatively impacting our residents. Kentucky also had a very similar bill that has no mention of restrictions on what the towns can do. If we're going to move forward with it, I have recommendations on what we should change. I'm just not sure, we have the time in this moment, which is again why I'd say re-refer. There's a lot of energy concerns, consumption of energy, consumption of water. The towers need the water to cool down. Is this going to be on the backs of the taxpayers? I think we just have a lot of unanswered questions. I know we have a lot to get through today, but I just think that what happened in some of the other states that duplicated this bill was a lot of unregulated growth. The law opened the floodgates for cryptocurrency data centers, and it set up operations without any consideration to the communities. Again, a strain on the resources. So I'd like everyone to just consider a re-refer and a commitment from me that we could work on this and get these problems fixed before we move forward and move too quickly. Thank you, Mr. Chair.
Further discussion?
I would agree with what my colleagues said. I think this bill needs to be studied a little more. There's a lot of energy consumption we're looking into, and I go back to when we were looking at electric vehicles, the amount of study we did on the infrastructure that it would take and the supply issues. So, I don't think this bill is ready for prime time. We heard it in testimony. And if we want to move forward with something like this, I would support a re-refer or even changing it to a study committee, but I can't support this bill as is.
All right, thank you, Senator Fenton. Senator Reardon.
Ditto to Senator Ricciardi and
All
Senator Fenton.
Okay, thank you. Further comments? Senator Murphy.
I just want to note, the one objection that I heard that had any merit to me was the sound, possible sound impacts, and the bill specifically recognizes that towns can still put in place noise ordinances that would affect the placement and would be effective. So the noise argument to me goes away with the presence of that language. So I would support the bill. I think it sends a strong message to the tech world that we're welcoming and makes us potentially a home for eventually some great industries. So I would support the bill.
All right, thank you, Senator Murphy. Further discussion. Senator McHugh.
Thank you, Mr. Chairman. So I support this bill for the following reasons. This has tremendous ability to impact attracting technology to New Hampshire. New Hampshire's been first in an awful lot of things. We've been first in biotech. We've been first in supporting investment, measured investment in crypto. This sets us apart. We were first in some LLC legislation years ago. We were first in some trust legislation. So this sends a message to the business world that we want to attract that talent, retain that talent from our schools. So there's been some objections raised for power consumption. This actually has the ability to positively affect the management of our grid and the resources, specifically the transmission and delivery aspects of our grid. So if you think about the practical aspects of how you wear out an appliance, think of a transformer on the grid as an appliance. It gets plugged in and unplugged repeatedly, and how much that wears on it. This industry, should it set up, has the ability to balance that load and act almost like as a surge suppressor in a very rudimentary sort of way. First of all, with the cost of energy in New Hampshire, it's relatively unlikely that there's going to be a major impact from these types of centers initially. But what it does is it sends a message in a fairly measured approach, allowing for localities to adopt noise ordinances. Some have noise ordinances now, and some do not. And we've heard objections to water consumption. So think about how liquid cooling works now in your car or in liquid cooled PCs or servers. Most of those are closed loop systems. So the water, sure, is used, it's heated up, but it's in a closed system. That's how liquid cooling works. So we're not talking about a nuclear reactor where water could be potentially discharged into a system, a river, lake, or stream. So we're a long, long ways from that. I ask you to support this, to send a message to the technology world that New Hampshire welcomes business, welcomes innovation, and we're not going to stand in the way of progress.
Thank you, Senator McHugh. All right, any further discussion? I'll make a motion about to pass on House Bill 639. We have that? I wondered. Okay, thank you, Aaron. Appreciate it. All right, so let's take up the amendment first, 25-1909S. All in favor of the amendment from Senator McHugh, please say aye.
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 Any opposed? No? All right, one opposed. Two opposed. All right. And on the bill itself, House Bill 639, all in favor of the ought to pass motion, please say aye. Aye. Any opposed?
No.
We're at 3-3, Mr. Jones.
Move ITL.
We have a motion to ITL
Second.
and a second. Is there discussion? All in favor of the ITL motion, please say aye.
Aye.
Any opposed?
No.
No. All right. So we are 3-3 on that as well.
Re-refer.
And now we have a motion and a second on re-refer. All in favor of the re-refer motion, please say aye.
Aye.
Opposed?
No.
And we're at 3-3 again.
I think we're headed to the floor with our recommendation.
You think what?
Go to the floor.
Go to the floor without recommendation. That's
Sure.
correct. So on a 3-3 vote, this goes to the Senate floor without a recommendation where it will be voted on there. Yes, I'll be taking this out. All right. Thank you, Senators. We have a substitution for 649. Welcome Senator Perkins Cloca to sit in for Senator Fenton. So we are at everyone's favorite bill, second favorite maybe, House Bill 649. And this is the inspection bill for automobiles. And it's been a rather interesting journey on this one. But I will make a motion on 649 of ought to pass.
Second.
We have a motion and a second, and we have an amendment to this one. If I can get to the right pages. Pretty big binder at this point. All right. And the amendment comes from me. It is 2029S, and I'll make a motion about to pass on the amendment. And we have a second. So what the amendment does is it focuses the inspections on safety issues and emissions every other year based on your birth month, and gives a couple of year exemption for new cars. And the idea here is to ensure that we have some level of safety inspection and emissions inspection, which is important, while also reducing a little bit of the burden on the average motorist who has to take time from work to go do these inspections every single year and put down a little bit of money in the process. So I'm open to any discussion on the amendment or the bill. Senator Reardon, kick us off.
Thank you, Senator. A global comment is, I think, being the owner of a 10-year-old car, and every other year inspection is not a wise idea. And I'm not sure what the age of cars are in the state of New Hampshire.
12.8, I've heard.
12.8, so there we go. And the other things I would say, if we are considering this amendment, there's some small changes that may need to be made.
All right.
I'll go to page 2, line 20.
Uh-huh.
It says for school buses and non-commercial vehicles.
Yes.
And I'm pretty sure the intent is commercial.
Oh, it is. You're correct. Thank you for that.
And on page 7, at line 22, the last word axle, I don't think we need axle rows. I think we mean the axle of a car.
Wait a
there.
minute.
So there's a misspelling, the AXL.
Oh, AX.
Yeah.
Yeah. Yeah, okay, good. It does not say axle rows for
It doesn't.
clarity. It
spelling is
misspells
consistent
axle.
with it. And lastly,
Good catch.
on page 10, line 8, the contingency of when this provision would go into effect, and it's about the environmental plan. I believe it's a section 15 right there. I believe we mean section 16 because section 15 is about the equipment on the car,
Okay.
but section 16 provides when new vehicles would be required to test. So I think that's just a typo,
Okay,
both on line 8 and line 15, where it says 15, it should be 16.
okay, very good. Thank you for that.
Thank you.
Appreciate it. Other comments on the amendment or the bill?
I have Mr. Chairman, too.
Yes, sir.
If I may.
Yes.
Car inspections became nationalized during the oil crisis, because the thought was that better maintained cars are going to use less gas. That was where we did it in New Hampshire before that for reasons of safety, but nationally it became a big thing then. And then just like the national speed limit, more and more states have been getting rid of it. And every study done says these car inspections are ineffective. Cars from those 39 states drive through our state all the time. And it's not as if we see cars from those states littering our highways. When we go to those other 39 states, it's not like cars are littering the highways. Every single study done says they're ineffective. It is a way to make money for auto dealers, which is why we've seen such consistent lobbying from that industry group. I suspect I'm the only one who hasn't been lobbied very hard on it, and it's because I have not been quiet on my position on the bill. I think we should be getting rid of them completely, and I would support the amendment as a halfway step. The sky will not fall, our cars will still operate, and I also want to say our constituents are not children. They don't need us to tell them when to go to the doctor, when to eat their vegetables, and when to get their car looked at and their brakes checked. Cars are better now than they've ever been. They last for a lot longer. And I am not here to force my constituents to the local mechanic once a year or even every other year. This is a compromise position. I'll support it as a good intermediate step, and I hope that the committee will pass it today. Thank you.
Thank you, Senator Murphy. Senator Perkins Coca.
Well, hello,
Good
Chairman.
morning.
Nice to be here with you. So I just want to echo some of the comments of Senator Reardon. I think we see this as an improvement to the bill. If this bill is going to move forward, we do want to see some amendment to it. There's been a lot of argument that our inspections are needed. We are a state where we don't require insurance. If someone were to be driving an unsafe car and a family were to be injured, there's little to no recourse for that other family. So making sure that all of us are respecting the rules of public safety when we're on the road are important. Unfortunately, this amendment goes just a bridge too far by only requiring inspections once every other year. But there are some good improvements in here that I think do address the idea that we're sort of making inspections simpler, and for those who can least afford to have their car repaired, depend on their cars to get to work and stay employed. There are some improvements here that will help address that population. Again, unfortunately, the language on page 2, line 13 about inspections being once every other year is something I can't support, but otherwise, we are looking to improve this bill.
All right, thank you, Senator. Appreciate it. Other comments? Senator McGue?
Thank you, Mr. Chairman. I agree with much of the sentiment that Senator Murphy mentioned, and we've heard so much public outcry about some of the nuisance failures, specifically in the onboard diagnostic sensor aspect of the inspection process. Those check engine lights that can cost thousands and thousands of dollars in some of the older vehicles, and for some of the folks that can least afford it. I'm hoping that the committee would entertain on page 2, line 8, and anywhere else that's referred to, taking out the onboard diagnostic system. That was the number one complaint that we heard from voters. So I'd like to strike onboard diagnostic system there. And additionally, I think there's perhaps a typo in page 2, line 21, where it's at the very, very end, where it says, which shall not exceed 16 months. That should perhaps either say 24 or 28. Because if you take 24 and add it to the 4 months referred to in line 15, I think that would be the maximum.
Yeah.
If you registered your car early, based on the ability to register early,
yeah,
I think it adds up to 28. So I think those two changes, this does represent a really good compromise, a great first step. We can address some of the minor details on the other pages about a list of approved headlights and some of these other things. They'll get addressed further down the road. But this is a great first step to decrease that consumer tax, still encourage people to drive safe cars, and have their safety checks done, but perhaps alleviate some of that burden.
Thank you, Senator. Senator Ricciardi?
I also have an amendment to introduce. It's Amendment 2110S. This amendment is very similar to the amendment that Senator Innes has.
If I could, Aaron, do you have a copy of the amendment? Okay. All right, please continue.
Does anybody?
Okay. It was put late here on my desk, just so you know, but okay. So this amendment is very similar, but in listening to what people want, taking into consideration other safety issues, taking into consideration what the towing people said, the motorcycle people, the troopers and everything else, I believe that what we need is good compromise. Compromise is the first step in ensuring safety, but also trying to please the people that we represent. And this amendment is a compromise that will blend short-term exemptions for low-risk vehicles with annual inspections for all other vehicles. It offers a reasonable middle ground. It acknowledges the proven reliability of new vehicles while preserving the critical role of annual inspections for older, high-risk vehicles where safety issues are more likely to develop. If your car is 5 years, new to 5 years, you would not need the emissions, but it would require older cars where that seems to be the issue. And the bill also has reduced a lot of the complaints that we received when you go to get your car inspected. It reduces that to more basic safety issues. And I believe that this amendment, with all of the support that I've heard from, as I previously mentioned, is a good compromise and a good first step. Thank you, Mr. Chair.
Thank you, Senator. Any further discussion? All right. So Aaron, in terms of process, we've had some suggested changes to my amendment. Should we do those changes as a committee amendment to the amendment? How's the process? Yeah. Right. Mm-hmm. Well, I think it's really not that bad. So let me just sort of run through what I've heard on the amendment 2029. Based on Senator McHugh's comments, and I think several folks feel this way, line 24 on page 1, taking out the onboard diagnostic system. On page 2, line 8, taking out onboard diagnostic system. On line 20, taking out the non in front of commercial. Line 21, changing 16 to 28. Fixing the word axle, line 22 on page 7. And the last one is line 8 on page 10, changing section 15 to read section 16.
And also on page 10, line 15, changing 15 to 16.
Okay, on line 15, also changing section 15 to section 16. And the final thing I'd note here is we have an effective date of January 1st, 2027, which gives folks time to get this implemented and get everything in place. Yes, sir. Diagnostics. Do we need section 15 emissions?
Mr. Chairman, do you want to take
I
it?
think so, yes. Those are sort of separate systems, right? Yeah, those are different. Okay.
You can move it.
Mr. Chairman,
Ask for recess.
I don't see it.
Mr. Chairman,
Yes, Mr. Senator.
we take a 1-minute recess.
Commerce will take a 2-minute recess. All right. All right, Commerce will come out of recess. So we have one amendment that's been moved. I understand there's another amendment, Senator. Shardy. Yeah, I'd be happy to have a vote on my amendment. So let's start there.
No, we have an ought to pass, don't we?
No, sir. Heck no.
So I think the pending action is on the committee amendment.
It's on 2029, which we've amended as a committee. Yes, all right.
Well,
Thank
I don't
you.
think we voted for the committee amendment.
We have not.
Yes.
All right, so we have the committee amendment to amendment 2029. And I'll make a motion about to pass on that.
Second.
We have a second. All in favor, please say aye.
Aye.
Any opposed?
No.
We're at 3-3. All right, is there another amendment?
Yeah.
All right,
I
go.
spoke to it,
All right.
2110S.
All right, and do we have a motion?
I mostly want to pass.
Second?
And we have a second. All in favor, please say aye.
Aye.
Opposed?
No.
No. 3-3. All right, that brings us back to 649 as is.
Move re-refer.
Move ought to pass.
I think I beat him.
Yes, the pending motion is ought to pass. So, all in favor of House Bill 649, please say aye.
Aye.
Opposed?
No.
And we are 3-3. All right.
Not recommendation.
Would anyone like to take this out, Senator Murphy?
Oh, sure.
And Senator, I'll plan to reintroduce my corrected amendment on the floor.
Mr. Chairman?
Yes, sir.
Senator McGee was asked to take it out. That's all right.
You asked what?
Senator McGee was asked to take it out. That's okay.
Oh, I'm sorry. Yeah, sure, that's fine. Okay. All right, Senator McGee will take that one out. Mr. Jones. All right. Let's go up to House Bill 60.
Thank you.
Oh, thank you,
Thank you.
Senator. Appreciate it. It's okay. I don't take that.
Well, I don't either. I just don't.
Well, everybody's leaving. It was worse than I thought. I think we did. All right. House Bill 60, which we've heard a couple of weeks of testimony on. Pretty good stuff all around. Yes, sir.
Move out to pass.
We have a motion about to pass on House Bill 60. I will second that. As I understand, Senator, we have an amendment.
Yes.
Okay, please speak to that.
Thank you, Mr. Chair. So let me first speak to this bill. You know, in principle, I don't have an objection to a contract. But with rental vacancy rates less than 1%, and while most landlords are good landlords, some may abuse it and worsen our homeless situation. There's already multiple ways to evict tenants: violating rules, disturbing neighbors, non-payment, destruction of property. You can raise rent, you can do renovations, you can move family members in. We've been sitting here fast-tracking housing bills to help with the housing crisis. And then now we're going to pass a bill that, well, will increase homelessness. It doesn't make any sense to me. Okay, so this amendment is a replace all amendment. And what this amendment will do is on line 3, there will be changing the minimum lease term to 12 months or longer. In the original bill, it was 6 months. Why? Because without this, the common practice will likely become these shorter 6-month leases, basically making each tenancy probationary. And if the tenant has to find 2 apartments in 12 months, that's easily $8,000 minimum between twice having to pay first month's rent, security deposit, and moving costs. Line 12 will add clarifying language that the eviction has to be filed within 6 months of the lease expiration. Okay, an explanation to that is without this, the tenant who has resided in their home 5, 10, 15 years could be evicted without any reason based on the expiration of the original lease. This would make clear that certain types of eviction should be deemed no fault. The essence of this bill is going to wait until the vacancy rate gets to 5% by the Federal Reserve numbers. This makes sense. It holds a contract, but it gives us the time we need to protect the people that are living in their rental units. And this is why I'm bringing this bill forward.
All right. Senator Ricciardi moves ought to pass on 1954S, an amendment to House Bill 60.
I'll second the amendment and ask to speak to it.
All right. Senator Murphy.
Thank you. I want to preface this by saying that I think I'm the only renter on the panel. I actually rent in North End. One of my constituents was here. We're probably neighbors. I am supportive of the bill because I believe a contract's a contract's a contract. The right to contract is one of the sort of the forgotten rights, and I wish it had been enshrined in the Constitution, but it wasn't. I also think that bad precedent and bad law has unintended consequences, and I think that the status quo actively discourages people from renting property, and we may actually see more people willing to be landlords if we put the state back in the where it belongs, which is enforcing contracts, not dictating contracts. Having said that, the housing market right now is broken, and it's broken because, in my opinion, it's been overregulated by the state and local governments. And I think that it is a good compromise and a good intermediate step to support the 5% trigger, so that we can hopefully get to the day that this contingency takes effect and the bad precedent is reversed and we're all sort of on the right side. Last thing I want is more people homeless. I think this is a good compromise and I would support it, but I will have a further committee amendment if we adopt this amendment, Mr. Chairman.
Okay. Thank you, Senator. Senator Fenn.
Thank you, Mr. Chairman. I'm struggling why this bill is needed. I may be the only landlord on this committee, maybe not, but I didn't ask for this. I don't need this. And I agree with what my colleague was saying that, we've been fast tracking these housing bills nonstop out of this committee. And, it's been great. We've been trying to provide housing for our constituencies. I think that's amazing. And then this bill just claws it all back. It feels like it's draconian. We're taking a massive step backwards. And I don't see the merits of this bill. I think it undermines basic housing stability. And, kind of goes against everything we've been doing this whole session in this committee, in my opinion. I'm for my colleague's amendment, but I'm going to be no on the bill because I think this bill needs to go away. I don't understand why this bill is here in front of us.
Thank you, Senator. Senator Reardon.
Thank you, Mr. Chair, and I'm going to agree with my colleague, Senator Fenton. We've heard from lots of large landlords, people that I've worked with in my career, Paul Stewart, Ben Kelly, who have said they've never needed a reason to evict, and they see this as a path to discrimination, to legalize discrimination. I did a lot of evictions in my legal work and never struggled for a reason to evict somebody when there was a legal cause for eviction. Coupling that with the testimony, really compelling testimony we heard from renters about how on edge they will feel now, and the folks from the DD community and NAMI about how fragile renting will be for their clients. I don't think people just move to another house, and I do think this is really going to burden cities and towns who are going to come up with first month's rent, last month's rent, and moving expenses, not to mention keeping somebody in a hotel while in fact they do that. So I think the downshifting is real. With that said, the amendment is much better than the original bill, and I will echo my colleague and say I am in support of the amendment. I'll vote against the bill because I really would like this to just go away.
All right. Thank you, Senator. Senator Ricciardi.
I do want to remind everyone listening that it is a replace all. This amendment replaces the bill. And that's why I'm going to support this, because we're replacing it. It's not the language you originally heard. Thank you.
Any further comments? All right, we have a motion about to pass on Amendment 1954S. All in favor, please say aye.
Aye.
Any opposed? We have an ought to pass motion on House Bill 60.
Mr. Chairman,
Yes, sir.
if I may propose a further committee amendment.
All right.
On line 1 of page 2, deleting housing vacancies and homeownership.
Line 1, page 2. Get to
Of the amendment.
thing of the amendment. So you want committee to amend this?
Yes, please.
All right. We already passed it. All right. That's all right. We'll reconsider.
Further committee amendment.
We can do a separate committee. Got it. All right. We'll do that then. Go ahead, sir.
Deleting housing vacancies and homeownership, replacing it with the rental vacancy rate,
Okay.
and deleting Census Bureau and replacing it with Federal Reserve.
Am I looking at the right? Where are you again, Senator?
Still on page 2, line 1.
Okay. Oh, gotcha. Yes.
The Federal Reserve is a much more reliable
Yes.
source. The Census Bureau is notoriously unreliable in
Yes.
data.
Senator Sharkey, you're comfortable with that
Yes.
change? All right. Okay, very good. Yes, Senator Reardon.
Question for Senator Murphy.
Yes?
I'm not familiar with that data. Does it look at just New Hampshire or just sections of New Hampshire? Is it broken down that way?
It's a statewide report. It's produced quarterly.
Could I ask a question, my colleague?
And it's generally held in pretty high regard for its accuracy.
I'm not opposed to it, but wouldn't it make more sense to keep United Census Bureau in there and just add in the Federal Reserve as well, so that we're getting data from multiple sources?
It's my belief and understanding that the Census Bureau is notoriously unreliable. It does not approach the accuracy of the Federal Reserve, and so if you have two choices between, why would you pollute your good data with bad data? This is the question.
And from my professional life, I can say the Census Bureau data is really good at the moment, a lot of times, but it's not as robust in this particular case as the Federal Reserve. So I personally think that's a positive change. All right, can we vote on the committee amendment to the amendment? Yes, I'll second it. All in favor, please say aye.
Aye.
Any opposed? All right, finally, we are back to House Bill 60. We have an ought to pass motion. All in favor of ought to pass, please say aye.
Aye.
Any opposed?
No.
Did you vote?
No. Repeat the question.
If you're in favor of House Bill 60, please say aye. And if you're opposed?
As amended.
As amended,
As
yes.
amended, yes.
Yes,
Yes?
as amended, yes.
All right, very good. Would you like to take it out?
Sure.
Okay. All right, very good. Thank you all. I think this is a reasonable outcome. We can move consent.
I'm fine with consent.
Move consent?
Right, I'll second that. All in favor, please say aye.
Aye.
Any opposed? All right, very good. House Bill 280, an act relative to wage payments. Do I have a motion, Senator Murphy?
280. I'll move ITO.
I'll second that.
All right, we have a motion and a second on House Bill 280. Discussion. All in favor of the motion of inexpedient to legislate on House Bill 280, please say aye.
Aye.
Any opposed? I'll move consent.
Second?
And we have a second. All in favor of consent,
Aye.
please say aye.
Aye.
Any opposed? Anyone want to take this out in case it's needed?
Sure.
Senator McHugh. All right, 296, building permits along private roads. Senator Murphy, well, let me first make a motion about to pass on 296.
Second.
We have a second from Senator Murphy, who has an amendment, 1899S.
I will move 1899S and ask for a second.
I'll second. Would you like to speak to your amendment?
Yes, Mr. Chairman. This amendment does two things. One is it strips the current Section 2 of the bill because it conflicts with an earlier bill the Senate passed earlier this session. And number two is that it restores the language from a different bill. If you recall, I believe the Senate Bill 173. We basically put in a statewide 30-day appeal period for the ZBA, which is currently the standard used by most towns anyway. It went to the House and they changed it to 45 days, which would actually be a downgrade from the current situation. So I'm looking to tack back on the 30-day language here. We've entered that season where we play these sorts of games. So I ask for your support.
Okay, thank you. Discussion. Yes, of
Discussion.
course.
More of a question, I think, but my concern is that when you use the private roads to build full-scale housing, but the towns would end up footing the bill for upgrades and maintenance. That's what I've heard as a complaint. Is anything here address that?
The amendment does not address that issue other than to point out that if there is determined to be an impact on services and expenses incurred by the municipality, they always have the ability to put in place impact fees.
Okay.
Okay. Further discussion? Senator Fett?
Thank you, Mr. Chair. I am a yes on the amendment. However, I'm going to be a no on the underlying bill. I think this bill needs a little bit of more work. I'd love to see it re-refer to get to a yes from me on this. I just know there's a lot of concerns about liability and the town's always, getting stuck with, yes, these people want to build on this, but then when they do need help, they still get the help. And I think there's a way to get to a yes, but I'd like to see it re-refer.
Okay.
Mr. Chairman, if I may.
Yes.
I think I can assuage my colleague's concern. The amendment strips the language regarding Class 6 roads and such. So it leaves the language in place for private roads.
Okay.
Well, that's why I'm a yes on your amendment.
Oh, okay.
All right, any further discussion on the amendment or the underlying bill? Seeing none, all in favor of Amendment 1899S, please say aye.
Aye.
Any opposed? All right. And we have a motion out there on 296. All in favor of the ought to pass motion, please say aye.
Aye.
Any opposed?
No.
No.
All right, 3-3.
I think it was
No.
4-2.
Oh, it was 4-2?
Yeah.
I missed that. Okay, all right. Thank you, senators. I appreciate that. So it was 4-2. Who would like to take that out? Senator Murphy, it's yours. House Bill 342 is next, and I understand we have a couple of amendments here. Do I have a motion on House Bill 342?
Move it off to pass.
We have a motion about to pass. Do we have a second? I will second it. And I understand Senator Reardon, you have 1981S to bring to us.
And 1981S corrects one problem in section 1 of the bill where it allowed, let me make sure I am clear about this, where it allowed allowed to build, so line 10 of the original bill, allowed to build on their property without seeking a variance for minimum lot size. My amendment just makes it clear that you can only build what's already approved in that zone. So in the middle of a residential neighborhood, you could only put a residence there. If in fact it was a neighborhood that was going to let you have a home business there or something like that, that would work according to the town. But that is the idea behind the amendment.
Okay, very good. Thank you for that. Any
So-
discussion on the amendment?
So I'll move amendment 1981S.
Okay, and do we have a second?
Second.
We have a second from Senator Fenton. Okay. And then, Mr. Jones, we have another amendment. Yeah, we'll vote on that one first, but then we'll get to it. All right, so let's go ahead and vote on 1981S. We have a motion about to pass with a second. All in favor, say aye. Aye. Any opposed? All right, that one carries. So Aaron, is there a copy of mine in here?
It's right in front of you, right up there.
Oh, okay, like this. Yes. All right, so I'm going to move on to pass on Amendment 2132S. Can I get a second on this?
Second.
All right, we have a second. So what this one does, you may remember earlier in the session, we did what was called the C-PACER bill. And C-PACER was designed to sort of separate out the cost of certain energy efficiency products in new construction. And essentially, and I won't go into too much of the detail here because we already had testimony in the vote. But essentially, it takes those costs out of the first mortgage on the property and finances them in a different way in conjunction with the cities and towns in the state. So the idea here is to, free up some capital by reducing the amount of that first mortgage to enable further construction. And the committee, as I recall, was unanimous in its support of this. So this amendment, the way the original bill was constructed, you had to go to a vote of the town to to participate in the program. And realize that's a fairly onerous thing and it might delay construction. So what this amendment does is pulls it to the select board in the communities. So the elected representatives of the community would decide whether or not to opt in and participate in the program. And that's all it does. So, discussion on it. Yes, Senator Reardon.
I will support that because it does make sense. CPACER was supposed to make development more likely to happen than not. And I will also say that the part of the mortgage that becomes the energy efficiency part lives with the property and stays
That's
with the
right.
town, but doesn't cost the town anything.
Correct.
So this makes sense.
Yeah, no cost to the local communities whatsoever. All right, further discussion. All right, all in favor of Amendment 2132S, please say aye. Aye. Any opposed? All right, and our underlying bill, 342. All in favor, please say aye.
Aye.
Any opposed? Do we have a motion for consent?
Moved. Second.
Motion and a second. All in favor of consent, please say aye. Aye. Any opposed? All right, very good. House Bill 450.
You can take that out.
Yes, who would like to take that out? Senator Reardon, thank you. 457, relative to occupancy of housing units. Okay, do I have a motion on this one?
Move on to pass.
We have a motion about to pass from Senator Murphy. Do we have a second? I'll second it. All right, discussion on this one.
You have an amendment, Mr. Chairman?
There is an amendment, 2082S.
Move that for sake of discussion.
Yes, I'll move that.
I'll second.
And we have a second discussion on Amendment 2082S. Senators, anything?
I'll chime in.
Okay.
This-
I know it is.
The amendment was the language suggested by the sponsor during her testimony. This would be essentially belt and suspenders, perhaps a bit redundant, but it would mirror the sentiment that this committee passed several times earlier this session regarding the towns that choose to dictate who can live together. It's been the sentiment of most of us in the committee that that's not appropriate and shouldn't be allowed. And this simply would I would say reinforce.
Yes.
Belt and suspenders.
Restate.
Restate. Yes, there you go. All right, good. Thank you, Senator. Any further discussion on the amendment? All in favor of the amendment, please say aye.
Aye.
Any opposed? All right, and the bill itself, 457, we have a motion about to pass. All in favor, please say aye.
Aye.
Any opposed? Do I have a motion for consent? I have a motion for consent. Do I have a second?
Second.
All in favor, please say aye.
Aye.
Any opposed? All right, 467 is next. Oh, yes, somebody needs to take it out. Senator Murphy, you got it. Thank you. I keep forgetting that.
Yeah.
Yeah.
Details.
There's a lot.
I move on to pass on 467.
We have a motion about to pass 467 with a second. This is an act defining social districts and enabling municipalities to create social districts. They don't have to do it. It's an option. Any discussion? All right, we have a motion about to pass with a second. All in favor, please say aye.
Aye.
Any opposed? Do we have a motion for consent?
So moved.
Sure. I'll
All right,
take
all
this
in
one
favor
up.
of consent, please say aye.
Aye. And I'll be happy to take it out.
All right, very good. Last one, believe it or not. House Bill 577, an act relative to modifying the definition of ADUs.
I'll pass.
I will second that one. And Senator Fenton,
I'm up.
You are.
I move, well, let's just do discussion. How's that?
Sure. Whatever the committee's pleasure. It's our last bill. We may as well have
You know,
fun.
it's called the bang then. I will, I think we discussed this last time. I kind of paused it a little bit.
Yeah.
I don't know if I need to reiterate a lot of it. You know, I think there's a lot of concerns with this bill. I think the merit of this bill is good. I'm all for ADUs. You know, Keene does ADUs. I got a couple small towns around me that may not like ADUs, but I think this bill, this amendment, 2050, I believe it is. Am I correct?
Yes, it is.
Fixes a lot of those concerns. Doesn't give everybody what they want. But I think I heard compromise in this room a lot. And I'm happy to go through this amendment line by line, or answer any questions that my colleagues may have, because I believe I went through this last time. I think you did.
All right. Discussion.
All right, I'm going to move Amendment 2050S.
We have a second.
Don't give me a second. Come on.
Second.
There you go. All right. We have a motion and a second on Amendment 2050S. Any further discussion? All in favor of the amendment, please say aye.
Aye.
Opposed?
No.
No. 3-3. All right. There was potentially going to be an amendment for me, 1400S. However, I'm not going to bring that one forward. All right. Senator Ricciardi.
I have an amendment that a constituent asked me to put in. It's 2092S. Can you pass it down? They weren't passed out. This basically is this constituent had a concern on the septic. So it was inserted in section 2 of the bill to amend RSA 674-72. So section 2 of the bill, and it would be replacing it with the following. It was a concern about the septic. So a municipality that adopts a zoning ordinance pursuant to the authority granted in this chapter shall allow accessory dwelling units in all zoning districts that permit single-family dwellings. One accessory dwelling unit which may either be attached or detached shall be a matter of right, and that the municipality shall allow one accessory dwelling unit without additional requirements for lot size except described in the section. It's concern about the septic, and that was why I was asked to put it in, about that the local pumping ordinances for septic would apply. That's basically it.
He can't. Okay. Thank you, Senator. Senator McGill.
Thank you, Mr. Chairman. I think this is maybe the most important housing bill we have. It's one of the most important housing bills we have amongst an awful lot. This bill lets you age at home. This bill lets you take care of your parents at home on your property, a luxury that you're really very fortunate to have if you do. This bill lets you give your kids a head start if they want to get out of college and not live in the basement, live in that bonus room that you never finished, in the barn that's on the property that you could finish to enhance the value of your property. It's so significant. It's hard to describe how many times I've driven around the district or the state and seen what could be a perfect dwelling for somebody getting older, perhaps somebody that's disabled that you might be taking care of and planning for, and you wonder how you're going to do it. This is such a critical bill for our culture and our family units. I really urge the committee to support this particular bill.
All right. Thank you, Senator. Further discussion, Senator Reardon.
Thank you, Mr. Chair. And a question to Senator Ricciardi about whether a line absolutely needs to be in here. And it starts at the very end of line 14 and says the municipality may prohibit accessory dwelling units associated with rented or leased land. Leased land happens in New Hampshire. All of Hampton Beach was leased land at one point. Every one of those houses on there was a 100-year lease. You got to use it any way you wanted during the 100 years. So I don't know. I've never surveyed New Hampshire for how much is leased or rented land, which I think those two terms are synonymous, but would you be opposed to striking that sentence?
No. Again, I was trying to accommodate my concerned constituent.
So from the last word on line 14 and all of line 15.
It's a fairly small percentage. It does happen sometimes. In fact, I looked at a particularly interesting property where the entire building was owned by a corporation, and a wealthy individual had, I think, the whole upper floor. But inside there was a 2-floor au pair apartment that owner wanted to maintain access to as he aged, in fact. And then his wife passed. And so it's a small bit. I think we should leave it there. I mean, if it's going to prevent passage, take it out.
Are you talking about?
Well, it was leased. It was a leased. This wasn't land in this case.
No, not, so this says leased land.
Leased land is the language.
Leased land. Sorry, where is it again?
Like the
Line
last
15.
word of line 14 and all of line 15 in the amendment, in Senator Ricciardi's amendment.
All right.
Thank you.
Further discussion?
Yes, Mr. Chair.
All right.
So, I support accessory dwelling units. I think they do a niche and a place. But what my concern is that most of the cities and towns in New Hampshire are already doing it. And they're doing it where it suits their town and their needs. Greenfield, one of my tiniest towns of all, has done very, very aggressive ADU. So again, we're just mandating from the state again, and that's my issue. I mean, I am a little concerned that with this, out-of-state investors could start just buying up our homes. And while I support accessory dwelling units on a at-need basis and your home and your property, I still think that there should be consideration to what the towns think they can support. So I know I'm never going to win this battle, but I want to represent my constituents and let them know that I am speaking out for them as they request it.
All right, thank you, Senator. Further discussion? All right, we have the amendment from Senator Ricciardi. I forget the number. 2092. Yeah, yes, Senator Ricciardi has made the motion. We have a second from Senator Fenton. All in favor of the amendment, please say aye.
Aye.
Opposed?
No.
No. I'm sorry, I put it. I'm a no.
Was that a stuttering senator or two senators?
It was a stroke, I'm sorry.
What's official protocol here?
Was it 3-3 or 4?
Can I just re-vote? I mean, I didn't get the voting. So, yeah. All right, all in favor of the amendment brought forward by Senator Ricciardi, please say aye.
Aye.
All right, all opposed?
No.
No. 3-3.
Lucky number today.
Indeed it is. So we have a motion on House Bill 577 of ought to pass. All in favor of the ought to pass motion, please say aye. Aye. Any opposed?
No.
All right. Looks like we're at 5-1 on that one.
I'll take it out if you like.
Should we move consent or is there?
No, I think we should not on this one because we'll probably be pulling it off.
Yeah.
I'm not.
To try to amend it a little bit further. All right.
I'll take it out if you like.
Yes, I will take this one out.
Yeah, all right.
All right.
Speak
That brings us to the end of our calendar. Is there anything further for the good of the order? Yes, they will be on this Thursday. So if we want to change. Yeah,
Wait, yep, this Thursday, like 2 days
this
from now?
Thursday.
Yes, there's
2
an
days from
amended
now.
calendar.
Yep. All right. Anything further? I will entertain a motion to adjourn, please. And a second. All in favor, please say aye. Aye.
Aye.
We are adjourned. Till next year.
Thank you, Mr.